The defendant explained that they had suffered a stroke last year. The judge responded calmly, acknowledging the situation and showing concern. "Yes, ma'am, I did," the defendant confirmed. Judge West paused for a moment, surprised by what she heard. "You had a stroke last year?" she repeated for clarity. "Yes, sir," came the reply. The judge then pointed out the seriousness of the matter. "After experiencing something that severe, it's concerning that you're still testing positive for substances," she said firmly. Her tone carried both disappointment and a reminder. Health and recovery must come before poor decisions.
Good morning, sir. Are you Devin Keith Byerly? And Mr. Byerly has two cases that he is currently on probation for, and motions to revoke probations have been filed in each of those. Cause number 18-28800, on probation for violation of a protective order, and also in 18-29063 on probation for violation of a protective order. Those are both deferred probations. Mr. Burbank has filed requests in both of those cases asking that I set bonds. Sometimes I do that without a hearing, but due to the nature of the underlying offenses as well as the new alleged offense, I wanted to come and hear from probation and the state as to what your position is with regard to any bond that I would set. Ms. Malfino?
Yes, ma'am. Judge, obviously I will defer to whatever Ms. Johnson thinks is appropriate. I do want to let the court know I did reach out to the complainant in the underlying offense. I've actually maintained contact with her just on a friendly basis since the original offense that I handled back in 2019, just to be able to assure the court that those issues do not involve that complainant, the issues that he's having now. There is no issue with the Hartley family, which I was glad to hear. Obviously, my concern is that there's been another assaultive offense. There's also been an allegation of a possession of a controlled substance. So 2 new offenses while on this bond, in addition to multiple violations, in addition to everything that Ms. Johnson has already made available to Mr. Byerly. So I know that he's entitled to a bond as he is on deferred.
Maybe he is without certain findings. So that's why we're here. So just also for the record, Mr. Byerly, and I know you know this, but I'm going to go through just so that we're all clear what the allegations are in that motion, and just that they're allegations, and obviously they haven't been proven true. But it looks like you have an allegation that you committed an offense of assault April 21st of 2025, that you tested positive in a urine sample for opiates, that you did not provide verification of attending the JCDI program. Looks like there was another urine sample that tested positive for alcohol in April of this year. Then it also alleges that you committed a new offense of possession of a controlled substance, May of this year, that you possessed crack cocaine, which is the same date as that offense, and that you were at a other location other than your residence at approximately 3:19 a.m. on May 29th, the date of that offense of this year. So what do you have the status? I know the lab, we've had some issues with lab results. Is there any idea on that, Ms. Malfino?
I do not know, Judge. I would venture to guess that with it only being several weeks ago, we probably do not have anything. I'm happy to reach out to the agency and ask if they can expedite that through the lab and be prepared for a hearing whenever the patient is.
And Ms. Johnson, thank you for being here. And so what is your thought, I guess, with regard to setting a bond? And if I did set a bond, what specific conditions do you think would be helpful?
I received his case. I became his officer in February of last year.
Okay.
And since then, I have put him in ISF cognitive. I have put him in JCDI. Prior, he's on an MRT. He tells us that he understands that he has a drug problem, but then still continues to do what he's doing. We've tried to help him as much as we can. And I went and visited him, I believe last week or 2 weeks ago, and he told me they were going to need a bond so he could go work out of the county. And I don't think that's a smart decision. If you put him on bond, I would say a drug patch would be smart. A GPS would be smart, but ultimately, Your Honor, it's up to you, but I don't think a bond is a smart decision.
Yeah, I don't either.
Can I have?
You may. Go
can I
ahead.
ask a question? When did you place him on JCDI? Do you have a date? When was he actually placed? Was it 2019? When he was placed on probation?
For probation?
Yes.
2019, May 13th.
When did you place him on JCDI? It was just recently?
Yes, sir. It was in the last.
February of 2025.
Okay, so what changed between 2019 and February 25 to say now you need JCDI?
His drug intake went up. We've tested on multiple occasions. He's tested positive for cocaine on multiple occasions, and we believe outpatient would be the best for him. He had spoken to me briefly as well that he had some issues he wanted to talk through. He had some family issues he wanted to talk through. So we got him in front of a counselor. Him getting the drug treatment is what he needed. He agreed with us. That's what he needed. So we believe that outpatient program is the best option for him.
Did he go to JCDI?
He did test positive on multiple occasions. He drank at one point and he admitted that to us.
So when did he stop going to JCDI, or was he still going at the time of this offense?
He was still going at the time of the offense, but since he picked up a new offense, they had to drop him from that program.
So it was the new offense that dropped him, and it wasn't him not going.
As well as the drug use.
And was there another program too that you said?
He had done ISF, cognitive track.
And what is that?
It is the interesting facility that we send people to, about 90 days long, and he went the cognitive track, so the thinking track.
And roughly when was that?
March of 2024.
Thank you.
All right, anything else, Mr. Burbank?
Mr. Barlow, you've heard what the probation officer said. Did you talk to the probation officer?
Yes, sir.
Speak up so we can hear you.
Yes, sir.
If the court was to allow bond, what is your plan in reference to what you would do when you got out?
As far as my plan, I mentioned to my probation officer, and I think we will mention also to you that I would like to get into our outpatient program at not break choice if possible, which will allow me to, I just told you I couldn't work out of the county. The reason why I asked for that was because I'm working at minimum 1,000 hours less than I normally work.
You are a longshoreman, is that
Yes,
correct?
yes, sir, I am.
And the incident in reference to the assault had to deal with your supervisor at the port, is that correct?
Yes, sir. It is.
And so the only ports that you know of are either Houston, Corpus Christi, or Louisiana that
I work at, and as far as making my payments and getting back on track,
If you enjoy watching real courtroom moments unfold, make sure to subscribe and stay connected. Each week, we bring you the most compelling hearings, the key rulings, and the real stories behind America's toughest courtrooms. From powerful life lessons to moments of truth, every case shows how one decision can change everything, even for those who faced major challenges, like recovering from a stroke and trying to rebuild their lives. Stay tuned. There's always more to learn from real justice in action.
I'm not worried about your payments.
you had a stroke last year.
yes.
And you're still testing positive for drugs after having a stroke.
Yes, ma'am.
Okay. All right.
Do you have a place to stay?
Yes, I do.
And where is that?
Two apartments, almost eight apartments is where I
Who
live.
stays with you?
No, I live by myself.
Who would supervise you? Do you have any family?
Yes, I do have
What
family.
family do you have?
My sister, Latoya Byerly, also my mother, Byerly, and I have an uncle, Mr. Williams.
And how far away do they live?
Well, as far as my mother and my sister, they live in Houston. As far as a good friend of mine, she lives right there in Fort Hall, in Frazier.
Do you have any kids?
Yes, sir.
Where are they?
I have one in, she's a cheerleading coach at Iowa State University. My son is in Yeah, I got 2 kids here in Beaumont, and one that I'm not allowed to see, and then also Tristan. I just reconnected with Tristan and my 11-year-old.
Mr. Violet, just one last question.
Listen,
How can you guarantee this court, if released, that you wouldn't be taking either alcohol or drugs pending the outcome of this hearing?
well, for one,
What guarantees?
I would accept that offer of the batch. And I agree, yeah, I just want to get back to work. What I do, I don't just go to work and come home.
You do other things. You've done other things.
Yes, I have.
So what's the guarantee that says you're not gonna do those other things when you're doing work and going home?
I just take the time off from my work, even though my capacity doesn't.
That's right.
Yes, and that's what I told him. You know, I see this as my last opportunity to keep everything that I have and that's.
One of the things is that you tested positive. What date was that, Your Honor?
I don't know, Mr. Burbank. What date is it?
No, I was wondering what date it was on the allegation.
There's a date of April, if I may.
Go
April
ahead.
29th, April
Did you
15th.
test positive for alcohol back on that date?
Yes, I did.
And was there a date also of positive for cocaine? Was there?
Yes, yes.
There was? So those allegations are true, correct? If the court is not considering a bond and that he needs help, he has pled true, Your Honor, to testing dirty at this point.
Well, he hadn't pled. We're not sworn in, or I mean, if he wants to plead to the motion, we can take care of that. With regard to the bond, the allegations, at least for that new offense on May 29th of this year, is that approximately 3 o'clock in the morning, 3:20 in the morning, you were sitting in a running vehicle in an empty parking lot in an area known for prostitution and drug use. You roll down the window to speak to officers. White smoke comes out of the vehicle. You get out. You got crack pipe, allegedly. 4 pieces of crack were found on you, allegedly. My fear is that I don't know whose car you were in, but obviously it's scary to think that you're out possibly driving in the middle of the night, either finding drugs, using drugs in the wrong area after this is your 5th administrative hearing. So you've already been given 4 opportunities with probation without having come in front of me on an MTRP. They've gone so far above by letting you work out things administratively with ISF, with JCDI, and I approved those things, but they did those things without saying, let's revoke his probation, let's work with them. And then here we are, while you're in supposedly the JCDI program, which is exactly what you say today you're asking for, outpatient treatment program. Based on the underlying offenses and the nature of those offenses, based on the nature of the 2 pending charges against you, I am going to find that setting a bond is not in the best interest in these cases of our community. I am going to leave it at no bond in these cases. We can handle this a couple ways. We can go through the motion. We can get pleas of true or not true. We can set it for a hearing for sentencing. If, depending on what the plea is on the, excuse me, the new charge of possession, we can get with the lab and I can ask them to get that done before that hearing. We can take care of that at that hearing.
Right, I'm advising not to enter a plea in reference to the new offenses until we know exactly what it is.
That's fine.
Maybe a question
I
on
think
that.
we can get that taken care of if I make that special request that they get that done in time. Do you want to go through the motion today?
Besides the new offenses, yeah.
Well, I'm going to go through the whole motion. He can enter pleas of true or not true.
Okay.
Mr. Byerly, raise your right hand the best you can. Excuse me. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, let me get this pulled up. different way. I think I can do it. So, will he waive the formal reading of the motion?
You will, Your Honor.
It's mine, Judge. I'm trying to turn it off.
Mr. Byerly, in 18-28800, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 13th of 2019, and that was a 10-year deferred probation for violation of a bond or protective order. And is that correct? And then in cause number 18-29063, that's what I need, thanks. Correct. I also have a first amended motion to revoke your unadjudicated probation. It also shows that you were placed on probation May 13th of 2019 for the offense of violating a bond or a protective order, third-degree felony, and that was a 10-year deferred probation. Is that also correct? Both of these motions allege that you violated your probation. Count 1 alleges that you committed the new offense of assault April 21st of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 alleges that you provided a urine sample April 29th of 2025 that tested positive for opiates, and is that true or not true? Count 3 alleges, in each case, that you failed to provide verification of attending the JCDI program as ordered. Is that true or not true? Well, he was attending, but you were discharged. So I'm going to put not true to the way that one is worded. Count 4 alleges that you failed to abstain from the use of any and all intoxicating substances, and that you provided a sample that tested positive for alcohol April 15th of 2025. And is that true or not true? Speak up, please. Count 5 alleges that you committed the new offense of possession of a controlled substance May 29th of 2025. Is that true or not true? Count 6 alleges that you possessed a drug, crack cocaine, May 29th of 2025. Is that true or not true? Count 7 alleges that you were at a location other than your residence at approximately 3:19 a.m. May 29th of 2025. And is that true or not true? Did you enter your pleas of true to counts 2, 4, and 7 freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 2, 4, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to reset your case for a sentencing hearing, ask probation to do an updated pre-sentence report, ask the state to bring any witnesses with regard to those other cases. We will set it at 11 o'clock probably, but we don't need a bunch of time, do we, on a regular day? We'll just do it at 11 o'clock. And if you need me to call the lab for any reason to make sure that that gets done as quickly as possible so that Mr. Burbank has notice of those results, then just let me know and I'll help take care of that if we can get that expedited. All right, we'll see y'all back at sentencing. Yes, sir, thank you. Give me just a second. Well, I had it up here and I had other stuff here. I had some of it. It's hard to have them both pulled up. And... Okay, yes, ma'am. What was it, 2, 4, and 7? He pled 2, 4, and 7.
All but the new allegations.
Yeah. Got it.
Well, the 2 allegations of it. And then there was one in reference to JCDI.
Got it. 2, 4, and 7. Okay. All right. Brandon Dodd, Mr. Burbank. Good morning. Are you Brandon Dodd? And this is 242418. Mr. Dodd is charged with murder. And Mr. Burbank, what is the announcement?
We have been, as you know, I'm the second attorney on this. Just retained. I'm just asking for one more reset. We're almost up to speed. There were some questions I've gone over and talked at length with Mr. Dodd and just requesting more time. There is a co-defendant, but that didn't
Okay.
No objection, Judge.
All right, and so what I'll do, yeah, it looks like you've just been on it a short amount of time. Mr. Dodd, I'm gonna reset your case one more time so you and Mr. Burbank can make sure you're both up to speed on everything that he's got, negotiations, and then we'll see if we can get an announcement at that next court date. All right, you can go back with the bailiff. See, is Mr. Gertz? Yes, sir, thank you. Mr. Kimler. Mr. LeBlanc, you've got Linton Arsenault. Did I pass my? I hate that. I get those. It was one of those tickles that wasn't getting. I know. I've got water in. It's just one of those that gets you. Yeah. Good morning, sir. Are you Linton Arsenault? And this is 242190. Mr. Arsenault is charged with failure to comply with sex offender registration requirements. Mr. LeBlanc, what is the announcement?
Just I've gone over everything with him that we thought, and we talked to Mr. Honkpower regarding the account offer. I believe it's going to be something we'll have worked out.
You believe it'll be what?
It'll be something we have worked out, I think.
Okay. And Mr. Honkpower's out this week, but he'll be back next week, right?
Yes, Judge, and Mr. Long did come and get the media
Okay.
for this case as well.
Good.
I just have not discussed the offer with him. I'm happy
Sure.
to do so.
So what I'm going to do, Mr. Arsenault, is reset your case one more time, and it'll be that last reset. That'll give Mr. LeBlanc time to talk to the district attorney's office, make sure whatever offers they have, any negotiation is complete, make sure you've seen everything they have, and then we'll get an announcement at the next court date. Okay? Thank you, sir. You can go back with the bailiff. Thank you, Mr. LeBlanc.
This courtroom session with Judge Raquel West was a perfect reminder of what happens when second chances start to run out. The first defendant, Dean Keith Barley, had already been given more opportunities than most. His case centered on repeated probation violations and a pattern of missing court dates without strong reasons. When questioned, Barley offered one explanation after another: confusion about scheduling, miscommunication with his probation officer, and so on. But Judge West wasn't convinced. She made it clear that the court doesn't operate around anyone's personal schedule, and that showing up is the absolute minimum expectation when freedom is on the line. After confirming that his latest drug test came back clean, she chose to reset his case, granting one final chance to get things right. Her tone, though calm, carried a warning. Another mistake could mean the end of his probation and the start of something far more serious. Next was Brandon Dodd, standing before the judge for a different reason: substance use while on probation. Brandon admitted openly that he had recently relapsed, and the honesty immediately caught Judge West's attention. She didn't raise her voice, but her message was unmistakable. Probation is a privilege, not a guarantee. Continued drug use, she warned, could send him straight back to jail. Still, instead of giving up on him, she offered one more path forward: a chance to get clean under strict supervision. Her tone was firm but steady, reminding him that it's never too late to turn things around, but that real change starts with honesty. It was a powerful moment, one that showed Judge West's rare ability to balance compassion with accountability. The final case involved Linton Arsenault, a defendant struggling with noncompliance and lack of effort. Throughout his probation, he had failed to meet his court obligations, missing classes, skipping check-ins, and ignoring orders meant to help him stay on track. When he appeared before Judge West, she wasted no time getting to the heart of the issue. She asked him directly why he hadn't followed through, but his answers were unclear and unconvincing. The judge reminded him that probation isn't a break before prison. It's a second chance to rebuild within boundaries and structure. She gave him one last opportunity to prove he could meet those expectations, warning that if he appeared again under the same circumstances, leniency might no longer be an option. Together, these three cases painted a vivid picture of how Judge Raquel West runs her courtroom, with fairness, firmness, and an unwavering demand for accountability. There were moments of frustration, honesty, and reflection, but one message stayed consistent: the court's patience has limits. Every defendant that day was reminded that freedom must be earned through responsibility, not excuses. In the end, each case had its own outcome and lesson. Dean Barley walked out with one more chance to prove himself. Brandon Dodd left with a warning and a path toward recovery. And Linton Arcino faced the reality that structure might be the only thing keeping him from losing his freedom altogether. Judge West summed it up through her actions. If you want another chance, you have to earn it. No shortcuts, no excuses. Only proof through effort and change. If you found this breakdown meaningful, make sure to like, subscribe, and turn on notifications. Every session in Judge West's courtroom tells a real story about justice, discipline, and the choices that define our future. Stay tuned. Next time, we'll see who earns redemption and who runs out of chances.